a 57-year-old man. No criminal record, no history of violence, no mental health issues, no criminal charges. His teenage granddaughter made one phone call claiming he was acting irrational. 3 officers arrived at his home. They all agreed no crime was committed. The granddaughter's complaints were completely false. And within 12 hours, this man was forcibly held in a psychiatric facility, threatened with permanent detention unless he surrendered his firearms, and his guns were confiscated without a single warrant. Not a warrant for entry, not a warrant for seizure, nothing. And the Supreme Court just refused to stop it. Here's what makes this ruling catastrophically dangerous for every gun owner in America. The legal exception the government used to justify this warrantless seizure, the special needs exception, could be applied to you tomorrow, based on a single phone call from anyone who claims you seemed irrational. I'm Sarah from Firearms Law Advisor, 5 years in the firearms and constitutional law space. And what just happened in Torsivia versus Suffolk County is a Fourth Amendment emergency that every gun owner needs to understand right now. Before we go further, Firearms Law Advisor exists for one reason: to give you clear, accurate, legally precise breakdowns of constitutional cases that directly affect your rights. Zero spin, zero political theater, just the facts and what they mean for your freedom. Hit that subscribe button right now and turn on every single notification. Cases like this develop fast, and the legal implications are moving at extraordinary speed. When new developments drop, you need to know within minutes. Drop your state in the comments immediately. And tell me, did you know the government can potentially seize your firearms without a warrant under the special needs exception? I personally respond to every single comment. Let me walk you through exactly what happened in Torsivia versus Suffolk County, because the facts of this case are genuinely alarming. April 6th, 2014, early morning. A teenage granddaughter calls social services claiming her 57-year-old grandfather is acting irrational. No specific threat, no weapons mentioned, just acting irrational. Social services contacts Suffolk County Police. 3 officers arrive at the home. During their assessment, all 3 officers agree he committed no crime. The granddaughter's complaints were completely false. Then, during the conversation, one officer accidentally knocked over a magnetic door drape. When the homeowner moved to pick it up, the officer screamed at him to stop and threatened to tase him. The man responded calmly, "Please don't tase me. I have a heart condition and could die." The officer interpreted that as a threat. He was arrested, transported to a psychiatric facility for evaluation. While he was being evaluated, an officer ran a computer check, found he had a New York pistol license, therefore likely had firearms at home. That officer contacted his sergeant. Sergeant ordered, "Get the guns." Both he and his wife refused consent to the seizure. Refused. Multiple times. Then, after 12 hours, his psychiatric evaluation came back completely clear. He was medically cleared for release, but a social worker told an intern to get the gun safe combination before releasing him. Render your firearms or stay in this facility. Despite being cleared, despite no warrant, despite no crime, he surrendered his firearms under direct threat of continued unlawful detention. Comment right now. What state are you watching from? And have you or anyone you know ever had law enforcement attempt to seize legally owned firearms without a warrant? Drop your state and your experience. I want to see how widespread this pattern actually is. Here's the legal argument the government used to justify every single thing that happened to this man, and why it's so dangerous for every gun owner in America. The government invoked what's called the special needs exception to the Fourth Amendment's warrant requirement. The argument government functions beyond normal law enforcement serve such special needs that they justify bypassing the normal warrant requirement. The Second Circuit Court of Appeals agreed. They found that under special needs exception, law enforcement could confiscate firearms based on a single phone call claiming someone was acting irrational, without a warrant, without a court order, without any formal judicial review whatsoever. But here's the legal problem that should alarm every constitutionally informed American. There is a unanimous Supreme Court decision, Caniglia versus Strom, that deals with almost identical circumstances. In Caniglia, the Supreme Court ruled unanimously that the community caretaking exception does not apply to warrantless entries and seizures inside homes. Justice Thomas, writing for the majority, was explicit. The very core of the Fourth Amendment's guarantee is the right of a person to retreat into their own home and be free from unreasonable government intrusion. The Second Circuit in Torsivia essentially ignored Caniglia. The only mention of that unanimous Supreme Court ruling was a single footnote. They simply asserted that the special needs exception is different from the community caretaking exception, without meaningfully explaining why that distinction should permit warrantless seizure of firearms from a man who had been cleared of any mental health concern. Tell me in comments, do you think there is any meaningful constitutional difference between the community caretaking exception and the special needs exception when both are being used to justify warrantless seizure of firearms from innocent people? Type no real difference, or they are legally distinct. Because this distinction is exactly what courts are debating. Here's where this ruling creates the most serious long-term danger, and where the Supreme Court's inaction matters enormously. The Torsivia legal team petitioned the Supreme Court for review. They argued plainly and directly that the Second Circuit refused to apply a binding, unanimous Supreme Court decision. They called it the plainest of plain error, if not an outright resistance to this court's authority. That is extraordinary language. Attorneys don't accuse a federal circuit court of resisting Supreme Court authority without serious basis. The government's response was technical. They argued the Caniglia case doesn't apply because the petitioners didn't separately and specifically allege unlawful entry into the home on distinct claims. They argued the special needs exception and community caretaking exception are legally different. They asked the Supreme Court to deny review on procedural grounds. The Supreme Court denied certiorari. They will not review this case. Here is the critical reality every gun owner needs to understand about what that denial means. When the Supreme Court denies cert, we don't always know why. There is no explanation. There is no dissent explaining the reasoning. The denial could mean the court agrees with the Second Circuit. It could mean the court believes the case was improperly structured. It could mean the justices want a cleaner case to establish the principle. What it does mean, the Second Circuit ruling stands. New York and the states within that circuit can now point to this Supreme Court denial as implicit support for warrantless seizures under the special needs exception. That is dangerous precedent spreading in the wrong direction. Drop your prediction in comments. Do you think the Supreme Court will eventually take a case that directly confronts whether the special needs exception can justify warrantless seizure of firearms from law-abiding gun owners? Type SCOTUS will take it, or lower courts will set the standard. I want serious predictions from people following these cases. Let me translate this ruling into practical impact for your daily life, because abstract constitutional law only matters if you know what it means when officers are at your door. Reality 1. In states under the Second Circuit's jurisdiction, New York, Connecticut, and Vermont, law enforcement now has implicit judicial support for claiming the special needs exception justifies warrantless seizure of firearms based on a welfare call. A neighbor calls claiming you seemed upset. A family member calls claiming you were acting strangely. That call alone could initiate a process that ends with your firearms seized without a warrant, while you have legal options only after the seizure has already occurred. Reality 2, if police arrive at your home regarding a welfare call and you legally own firearms, do not consent to any search or seizure. State clearly and calmly, I do not consent to any search of my home or seizure of my property. I would like to speak with an attorney before any search or seizure takes place. Document every word of the interaction. Reality 3, never surrender firearms under threat of continued detention without consulting an attorney. The threat Torsivia faced, surrender your guns or we won't release you, was itself potentially unlawful. His compliance under that threat was coerced. That coercion is now part of the legal record in ongoing post-case litigation. Reality 4. This case is a clear preview of how red flag laws operate in practice. The same warrantless seizure logic, the same welfare call trigger, the same absence of judicial warrant before seizure. Understanding Torsivia prepares you to understand and challenge red flag enforcement. Comment your answer. Do you own firearms in a state that has red flag laws? And after learning about this case, are you more concerned about how those laws could be applied to you personally? Type "more concerned now" or "already knew this risk," because this community needs real data about awareness levels. Let me put Torsivia in its broader constitutional context, because this case doesn't exist in isolation. It's part of a pattern every gun owner needs to recognize. The Fourth Amendment and the Second Amendment are deeply intertwined for gun owners. Your right to keep and bear arms means nothing if the government can enter your home and seize your firearms without a warrant whenever they invoke a sufficiently flexible exception to the warrant requirement. The community caretaking exception, the special needs exception, the emergency exception. Each one represents a category of government action that courts have carved out of the normal warrant requirement. And each one represents a tool that can be, as firearms from law-abiding Americans without judicial oversight, the Fourth Amendment was designed to guarantee. Cornelia versus Strom was supposed to draw a clear line. Warrantless entries and seizures inside homes cannot be justified by the community caretaking rationale. 9 justices, 0 dissents. The line seemed clear. Torsivia demonstrates that the Second Circuit is willing to reframe the same government action under a different exception label. Special needs instead of community caretaking, and reach the identical result. The unanimous Supreme Court ruling effectively circumvented through relabeling. That is the pattern gun owners need to watch. Not just the constitutional argument, but the government's willingness to relabel the same conduct to avoid binding precedent. Tell me in comments which constitutional protection do you think is most at risk for gun owners right now? Fourth Amendment warrant protections, Second Amendment carry rights, or NFA registration requirements. Drop your priority and why, because I want to understand what this community sees as the most urgent constitutional threat. Here's the bottom line. A 57-year-old man with no criminal record, no history of violence, and a clean psychiatric evaluation had his legally owned firearms seized without a warrant were under threat of unlawful continued detention based on a false complaint from his teenage granddaughter. The Second Circuit upheld that seizure. The Supreme Court refused to review it. And now, law enforcement in New York, Connecticut, and Vermont can point to that denial as implicit support for warrantless firearms seizures under the special needs exception. The constitutional question of whether that exception can justify warrantless firearms seizures from law-abiding Americans remains dangerously unresolved. And the Coniglia unanimous decision that should have answered it has been effectively circumvented through relabeling. Every gun owner in America needs to understand this case, because the legal machinery that was used against Torsivia can be used against you. Here's what you do right now. First, subscribe to Firearms Law Advisor and hit that notification bell immediately. Cases building on this ruling are moving through lower courts right now. When new developments drop, you need to know within minutes. I cover every development the second it happens. Second, smash that like button and share this with every gun owner you know. Most people have no idea this case exists or what the Second Circuit just allowed to stand. Third, answer every question I asked. What state are you in? Have you faced warrantless seizure attempts? What's your Supreme Court prediction? Which constitutional right is most at risk? Drop everything in comments. I personally read and respond to every single one. Fourth, how this ruling affects your state, red flag law interactions, what to say when officers arrive regarding welfare calls. Ask me anything below. 5 years in constitutional law and firearms rights. Real answers only. The Fourth Amendment and Second Amendment stand together. When one is undermined, both are threatened. Stay informed, stay documented, know your rights. I'm Sarah from Firearms Law Advisor. See you in the next one.